morning, good evening, good afternoon, whenever you're listening to this show. We, at this time, are recording in advance, so you are listening to The Divorce Duo. This is Christina Previtt.
I'm John Knocklinger.
And we are attorneys practicing family law, which to most of you means we're divorce lawyers. We practice primarily in central and northern Jersey and pretty much in most of the state. If you want to look at our blog or view our website and find out more about us, you can go to pnlawnj.com. You can find us at centraljerseyfamilylaw.com. You can also find us on Facebook, on Twitter, on Instagram. And you can email us at divorceduo@gmail.com. And we're airing on internet radio, panjradio.com.
Absolutely. And we are drinking wine.
Yes, and I still have a cold. So if you listened last week, I have not had a cold for 2 weeks. We're recording back to back, so I still have a cold from an hour ago.
That also means that we've had a little wine already. So
Yes.
Just keep that in mind as you're listening to the show.
I think John's had a little more than I have, though.
Well, I think your Dayquil more than makes up for the difference.
Yeah, I'm hopped up on Halls, sugar-free, and Mayomi, one of our favorite wines that we drink frequently.
Yes, which I found at Sam's very inexpensively.
Yes,
Yes,
very
don't worry.
happy about
I'm
that.
I'm going there tomorrow. So
And it's a twist cap.
it's a twist cap. Gotta have the twist cap. But it's a good twist cap. So before we get into the show, so I watch Grey's Anatomy. I know you don't.
I like it, but I've lost track of it, so I'm so behind.
So there's an interesting storyline which is related to family law, which is why I wanted to bring it up, where April and Jackson were married, and they got divorced. And of course, Jackson's mother owns the hospital, and now Jackson owns the hospital, or he's one of the owners of the hospital. But anyway, April and him got divorced. Well, it turns out April was pregnant before they got divorced, and something really interesting happened. It was either in last week's episode or the episode before, and I've never heard of this before, but I thought it was so interesting. Jackson's mother hatched this plan to actually sue April for fraud because she knew she was pregnant with Jackson's baby before they signed the divorce papers. Have you ever heard of such a thing? So in other words...
So they got divorced, she was pregnant and didn't tell him.
Yes.
I don't know. I don't see that going anywhere. I don't
know either.
What's
but
the damage?
I heard about it, but basically that, he's the one that wanted the divorce. So I think one of her claims is that he wouldn't have gotten the divorce if he had known this.
Well, that presupposes that she didn't want the divorce either at that point in time. Which
that's true. But the way that it's going, of course, it's a TV show.
Yeah.
However, I just thought that, the problem with TV shows is that we all watch them and we think, you can do that. I can do that in real life. So I think the issue here was, I heard that and I was like, fraud? Suing someone for fraud because they didn't tell you they were pregnant before you signed divorce papers? I just thought that was really interesting, and quite frankly, I don't blame her. You're getting divorced, like a day or two before you're about to get divorced, or actually probably not a day or two, maybe a week before you're about to get divorced, you have that last, romp in the sack, and whoops, you get pregnant. And, at this point, what do you do? Especially, you don't know the backstory with them, but April miscarried already. So I think maybe she just didn't want to tell him. But I just think it's really interesting. The moral of the story is, if you're divorcing somebody, don't have sex with them.
Come on, John. You know how many people are probably still having sex with each other and that are getting divorced.
Let's just say one of my clients, and you know who you are, went right to the parking garage after she was done divorcing her husband, and in the parking garage had sex. So,
well, I heard they did a few things before the divorce.
Before and after.
We won't be more specific than that, but
yeah, and you know who you are.
I don't think foreplay means before the divorce proceeding.
Oh my God.
I think there's a lot of you out there doing it, though.
So
And there's nothing wrong with that. Just don't get pregnant, okay?
please don't. So today in the news, we're going all TMZ on you guys. We're going to talk about some celebrities. And it's interesting. I mean, we joke around about it, but you do learn a little bit from looking at the way celebrities do things because everything's so public. You know every aspect of what's happening. Where a lot of times when people are going through divorces and custody disputes, it's all private, so you don't get to hear everything. So basically, we're all learning some interesting little tidbits. So I'm going to spring some of these on Christina and see what her response is. So the first one is Jennifer Gardner, everyone's favorite Capital One actress. And,
she's too nice and sweet.
oh my gosh, I know. And Ben Affleck.
Yeah, I mean, I think this is yet another instance in the news where he apparently, allegedly had an affair with the nanny.
Yeah.
I don't get it. What's up with the nannies? I would just get a really super ugly nanny.
Well, you know, since
Preferably a lesbian, because then I don't need to worry about my husband cheating on me with her.
so what's interesting is in the news, and this is according to U.S. Weekly or Us. Is it Us Weekly or U.S. Weekly?
Us Weekly, I believe,
Weekly?
John. I think.
Whatever. Us Weekly. So he's apparently filming in London for the next Batman Superman movie, whatever that's going to be
Wasn't the
called.
first one crappy? Why are they doing another one?
Well, Jason and I went and saw it, and I thought it was fine.
Okay.
It was.
All right, I heard it was bad.
It wasn't something I'm going to go buy on DVD, but it was okay. And Ben Affleck was actually a good Batman.
Okay.
You know, and let's be honest. There's been some not so good Batmans along the way, but he was pretty good. So he's filming in London, and the kids are there, and Jennifer's living with them.
I find that so strange. I don't understand how two people who are getting divorced. I mean, I understand most people do need to live together while they're getting the divorce, but that's generally very uncomfortable. Even if it's amicable. It's just uncomfortable. That's the way people have described it.
Well, I mean, but I know it's uncomfortable. But this is a really interesting dynamic. You know, they spent the holidays together. Affleck's on the record calling Jennifer a superhero mom. I mean, if you're going to co-parent, but you're not going to be married, they're really giving a good example for how to do it.
Yeah,
I think they're going a little overboard, but
those are the very best circumstances for the children is if the parents really can truly be friends and still because you're kind of still a family, even if you're not together. But it's really damaging to the kids when they know that their parents don't like each other, and they know even if you're not arguing in front of them, they just know. So that's, you know, I applaud them for that. I think there's probably a lot more to it than that we don't know. I suspect maybe one of them doesn't want to get a divorce and they're hoping that this is some opportunity at a reconciliation. And I also wonder how well that's going to go when the other one finds a boyfriend or a girlfriend. I mean,
yeah, but I mean,
how's that going to work?
I was going to say, if Ben wants to get divorced, you know, he's got all this Batman money coming in now. Maybe he needs to, you know, shit or get off the pot, so to speak.
I never heard anyone say shit or get off the pot in the context of a divorce. Usually it's to get them married, but
well,
you know what?
You know?
It does apply here.
In a lot of ways, it makes more sense with a divorce.
Jennifer's too nice, though. I mean, if he really cheated on her, I'm a big proponent of, you know, what Sandra Bullock did. She kicked him to the curb right away. You know, Gwen Stefani, too. As soon as she knew that Gavin was messing with the nanny, she was out of there. So, I don't know.
I love Sandra Bullock.
I love her, too. She looks amazing, by the way, and she's 50.
Yeah, she's good. I actually, I've liked her. I like her better now than I used to like her in movies. You know, I think she's got more substance to her now. So you're going to cry. We're running short on time, so we're not going to get to discuss your favorite person in the world.
Oh, God.
Kim Kardashian and Kanye West. But let's just say, according to very reputable media outlets.
Yeah. Like the National Enquirer. Are they even around anymore?
No, we're not going to talk about how, you know, Ted Cruz had affairs with 5 women. I don't know. He's so ugly. I don't know who would
And they
want
were
to do anything with him.
aliens, I bet. According
were.
to the National Enquirer,
But-
they were
but the-
probably aliens.
But this story is more about how Kim and Kanye are going to have, a custody dispute over Northwest and Saint West. And quite frankly, I think Child Protective Services should take the children away from both of them for naming their kids that.
Please.
Well, it's better than Apple.
Yes,
who is
I
that? Gwyneth
know.
Paltrow, right? Wasn't that Apple?
Yes.
I mean, I can't imagine how many therapists are going to be needed to help these kids. So
They're not getting a divorce. That was not from a reputable source.
Yeah, but
and
we'll see.
We've been hearing this.
well, Kanye West is God, so
Yeah, okay.
she might not want to. She might not want to
I think
divorce
he's
God.
psychotic.
Well, those Kardashian women don't exactly have a good track record with who they marry.
No, they really don't.
For as much money and how smart they are in business, when it comes to common sense in real life, they're not really up there.
But they are laughing all the way to the bank.
They are laughing all the way to the bank. All right, so today's top 10 list is about the final restraining order hearing. So last week we talked about what happens sort of before the hearing. So the temporary restraining order, what happens after you get the temporary restraining order. So you can go back and listen to the archives for last week if you want to hear about that. But this
And that would be on panjradio.com.
Yes, go to panjradio.com and you'll go to, there's a big YouTube link and you press that and you can find all of our past shows where you can listen to how wonderful and glamorous Ms.
It is.
Previtt sounds.
How glamorous it is to be a divorce lawyer.
It is. It says very glamorous. And you can also see the difference between the last 3 or 4 shows where we've been drinking wine and before that where we did not. So, and if you have any thoughts on that, please email us at
we're
divorceduo@gmail.com.
We're all ears.
So we'll start with number 1, which is what is the procedure of the final restraining order hearing? So why don't you get us started, Christina?
Yeah, well, what we want to impress upon you is that it is a real trial. Maybe not, law and order kind of trial, where you have the smoking gun and, somebody wins big. There's just some major piece of evidence that comes into the open.
You mean it's not a trial with a bunch of people sitting in the background, and whenever you do a Perry Mason thing, you hear a bunch of
That's right.
You hear a bunch of laughing and whooping and lawing.
Yeah, and it's always exciting
clapping and yelling.
And nobody seems to be waiting around there ever either. But you should be prepared to have a trial. You're not going to just go and hang out in the hallway and maybe talk to the judge. It doesn't really work that way. It is a trial, and there is some preparation involved. So if you don't have an attorney, then you need to be prepared to have some idea what's going to happen when you get there. And you need to be prepared to have a formal trial. So we don't have enough time to really go into all of the nuts and bolts of a trial. Maybe we could do that another time. If you'd be interested in learning that, you can email us and let us know that we should do a show on that alone. But you should be prepared. If you're plaintiff, you're going to address the court. You're going to explain again what are the allegations that you've made against the defendant as to what you claim are acts or is an act of domestic violence that was perpetrated against you. And you should be prepared to present any evidence that supports your claim. So if you claim that your husband, I'm going to generalize by gender, but it can go either way. You say your husband punched you in the face. Did you have bruises? Did you take pictures? It's always best if there's some physical evidence of that. Maybe you still have some residual injuries that are visible that day. You can explain that to the court. But if you have pictures, you should have those. If there were any witnesses that witnessed any of these events that you claim happened, you should have those people there so that they can testify and give their version of the story of what happened, just to corroborate your version of the story.
Yeah, I think what's most important is to understand that as the plaintiff, you have to prove your case.
Yes, and you have to do that by a preponderance of the evidence, which is a little different than what you may be familiar with in a criminal trial, which is beyond a reasonable doubt. It's a lower standard.
It means is there a 50.1% chance that you're correct?
That's right. You just have to demonstrate that it's more likely than not that things happened the way you say they did.
Right. So, and after the plaintiff does their case, an interesting little quirk is that at that point, the defendant can actually make a motion to dismiss the case at that point. And I know, Christine and I have talked about this many times. I've been successful, I think, 2 or 3 times making that application.
I have too.
Because a lot of times the judges hear the plaintiff's case and they're like, this is not domestic violence.
Yeah, and these aren't fun for the judge. If the judge is sitting there, maybe has heard an hour or more of testimony and has a line of people out the door that they have to do after you, they're pretty liberal if they get a sense that this is not a restraining order. It's not something that should have been a restraining order. They're pretty liberal, I think, granting those motions to dismiss. So if you're the defendant, you can do that when the plaintiff is done with her case. You can ask that the court dismiss it and just say basically that the plaintiff hasn't demonstrated her burden. She hasn't proven her burden sufficient to enter a restraining order. I'm oversimplifying it, but that's basically what you need to argue.
If we believed everything the plaintiff said, she still wouldn't be entitled to a restraining order.
That's right.
And a lot of times, because there's cross-examination, the plaintiff may already have been discredited before the defendant has to say a word. So sometimes you can make it, but if that's denied, then of course the defendant will put on their case and they'll try to convince the judge that either it didn't happen at all, or that there's no basis for a restraining order, or that there's some other mitigating circumstances of why there shouldn't be a restraining order, and then a judge will make a decision, and that's what the parties are going to have to deal with.
Yeah, I mean, we're just running through it so quickly. There's so many aspects that we just don't have time to get into right now. But, like I had said in our last show, if you can't afford to get an attorney to do this entire process for you, at the very least, I would highly recommend meeting with an attorney just for a consultation, and let them know that you want to meet with them specifically so that you can try to represent yourself and ask them to walk you through what the whole process is going to be like, and things you should say, maybe things you shouldn't say. We offer that service, and I know that many people have been very grateful for that. They come in for an hour or a couple of hours, and they at least feel a little bit more prepared to do it themselves.
Absolutely. So number 2 on our list is, what does the plaintiff have to actually prove to get a final restraining order? So you have to prove, number 1, an act of domestic violence occurred. And there's a whole list of things that may have occurred. The most popular ones are harassment, assault,
terroristic threats.
I'm going to kill you. Those sorts of threats. Those are the most common. I mean, there's other things like if you damage someone's property, that can be a basis for a restraining order. So there are some other things. There's some that are like super obvious. Like if you try to kill somebody, that's a basis for a restraining order. Yeah, and I just saw that
homicide, I never focused on this before, but apparently homicide. So if you are dead, if you have been killed by your batterer, you are entitled to a restraining order.
Oh, thank God. So if you were kidnapped, false imprisoned, restrained criminally, assaulted, obviously if there's criminal assault, sexual assault, I'm sorry. Lewdness. I've never done a lewdness one before, but lewdness.
What is that? What is lewdness?
It's showing your parts where you shouldn't be showing them.
Your ear? Your nose?
Basically what you do to your boyfriend every night. And then he rolls over and says good night.
Oh my God. All right, you just went too far, John. Too far.
And stalking. Stalking's another one. So you prove that, and then you're going to need to talk about past domestic violence, because it is rare that a single act of domestic violence would lead to a restraining order. It is possible, but it's not very common. It'd have to be something very extreme, like, for example, someone actually tried to kill you. But, for example, we were talking about earlier, 50 text messages might be the basis for a harassment claim, but you're going to need a history of domestic violence for that to actually lead to a restraining order.
And the reason that's important is because there's a case, and I don't like to cite cases and things like that, but it's Silver versus Silver. But, every attorney cites to it, and it is actually very important to know going into the courtroom.
Do you know what citing cases has done to me?
I know, right? We're so sick of all homework. It's like being a lawyer in general, I think it's like doing homework forever. It's like always, you do homework for a living. That's what you do. You read a lot, you have to write assignments.
That's why we're always talking about how we need wine in the office.
Yes.
So after you prove that there's an act of domestic violence, you talk about the history of domestic violence, then the court has to consider a couple other things. Like, for example, is there immediate danger to the plaintiff or property? I don't know why property is in here, but if there's an immediate danger, the court will consider that. The court also has to consider the financial circumstances of both parties, the best interest of the victim and any children that the victim has, if there's any custody and visitation issues, and is there any other orders from any other jurisdiction that may have some bearing? Like, for example, do you have do you have some kind of restraints that maybe aren't a domestic violence restraint in another jurisdiction, so that maybe there's a history that maybe you've done something in the past?
Yeah, and the whole purpose of all of this is just to determine does there need to be a restraining order in place? Does it need to be a final? Because it's permanent. And I think the judges generally do take that responsibility very seriously, because has dire consequences for the defendant. It's permanent. It's forever.
I think that's key, and we're going to discuss those consequences after we come back from the break. We're going to discuss those consequences, but you're right. I mean, the judges, I think, really don't want to give out a FRO unless it's absolutely necessary to protect the victim. And then, even then, what I tell everyone is, it's a piece of paper. It doesn't prohibit somebody from actually doing something. So, unfortunately, it only works if it actually discourages somebody from approaching you.
Yeah. So if you're a plaintiff and you truly are in a domestic violence situation, sometimes that piece of paper isn't going to matter.
No, it's not. I mean, those are the extreme ones, but unfortunately, those are the mostly legitimate ones. So moving on to number 3, which is what kind of evidence do you need? I wanted to start by talking about children testifying in domestic violence trials. Let's see, what is this? From last summer, the New Jersey Family Lawyer, which is the newsletter the family law section of the State Bar puts out, my good friend Richard Severin wrote a great article, which, if you can get a copy of this article, you should try to. I don't know how you're going to get it.
We can post it somewhere, I'm sure.
Yeah, I'll see if I can get his permission to post it, because I think it's a really good article. Because, we don't all think about children testifying in domestic violence trials as problematic, but it really is. Because let's say a 5-year-old's the only one who witnessed an act of domestic violence. Your instinct may be they need to come and testify, but you may not take into consideration what impact that's going to have on the child. For example, young children rarely remember events as they actually happened, and they're very subject to suggestion on what exactly happened. So when you've got children testifying, I think the interesting thing is, how are they going to testify? I mean, I think any judge will allow a child to testify if they were a witness. I mean, you can't say no.
No, I've seen judges really strongly try to deter that.
Yeah, I think if they absolutely said no, it would be appealable and reversible. So in this article, Richie was talking about the fact that it might be a situation where you conduct the examination and cross-examination in chambers with just attorneys, so that the child doesn't actually have to see the parents when they're testifying, or that maybe you do it through some kind of video conferencing where they're in another courtroom and you do that. Now, I've never done any of those things myself. I've had children testify, but they've all been 15, 16, 17, 18-year-olds, and that's hard enough. But, I mean, what is your feeling on that?
I think that it's always a last resort, whether it's a DV matter or any kind of other divorce proceeding. I think it should always be a last resort to involve children testifying against a parent. But sometimes, unfortunately, it is necessary. So if it's truly necessary to further the case, then I don't have anything against it. But I usually try to find other ways to prove whatever it is that you're trying to demonstrate.
I mean, I think the key is the child competent to testify? If they're competent, then there's really nothing you can keep out of it. In terms of other evidence, Christina actually already went through a lot of it. I mean, you're going to look at witnesses, you're going to look at, pictures, recordings. We have audio recordings. In fact, after the break, I'll tell you a story about an audio recording that I just thought about because it goes back to when I met Christina.
Oh boy.
Oh.
And you have to keep in mind too that it's just it's only pertaining to the allegations that have been made. It's not just I want to show the judge what a jerk my husband is and bring up these other things that are not relevant. So you have to really stick to something that's going to prove that these things happened the way I said they did.
Yeah, absolutely. So stay with us. After the break, we'll be back with more. You're listening to The Divorce Duo on PANJradio.com.
Sorry, I feel like I cut you off.
Are you having fun running your business marketing? Or does online marketing and social media overwhelm you? Would you like to use Facebook, Twitter, Pinterest, Instagram, Snapchat, or LinkedIn, to name just a few online social marketing opportunities to market your business successfully? Amplify Your Voice can help. We work exclusively with local businesses in the PANJ radio target area of Hunterdon, Mercer, and Bucks counties, offering social media workshops, one-on-one coaching, managed services, direct online marketing, and web design. Contact us today at 973-615-5287 or email us at radio@ampyourvoice.com for a free no-obligation review of your online marketing. You can also visit us at www.ampyourvoice.com. Amplify your voice in a crowded market. Together, we will put the fun back in your business marketing.
And the sun goes down upon this river town.
Hi, this is Judith Marchand with PANJ Radio. I'd like to invite you to listen to my new show, Musical Notes, where I will be interviewing different musicians at 8 p.m. every night. Tuesday nights I will have a new musician, and then it will air the rest of the week. We'll be finding out what these musicians are all about and listening to some of their music. So tune in. It's going to be a great show on PANJradio.com.
It's all authentic comfort food at Bitter Bob's in New Hope. Bob serves mouth-watering barbecued pork and chicken dishes, signature sloppy sandwiches, homemade cornbread, macaroni and cheese and collard greens, all the great southern dishes you crave for. Bob serves weekend brunch, lunch, and dinner, BYOB, with an outside patio that is dog-friendly, and he has a kids menu. Great desserts, too. And Bob can cater any event, big or small. Tell the waitstaff you heard this commercial and get 10% off. Bitter Bob's in New Hope, PA. Authentic comfort food for your family.
Welcome back to The Divorce Duo. We left off with number 4 of our top 10 things you need to know about the final restraining order hearing, and number 4 is surprises. So what surprises are in store, Christina?
Well, the surprises, not good surprises, not like getting a present or a check in the mail.
It's not like Oprah.
No.
You get a car, you get a car, we all get a car.
Yeah, no, nothing like that. The surprises generally happen because of something I touched on earlier, is that your clients don't tell you everything. So it's really important that you, as the plaintiff or the defendant, especially the defendant, you have to tell your attorney everything. So if you did something that's really stupid or you did something really embarrassing, you need to tell us, because it's going to come up when we're in court.
You know, and so I'll bring us back to what I left off with before the break. So Christina and I, we met on a case where there was a domestic violence portion of the divorce. And I showed up on the day of the hearing, and I had a nice audio recording that completely contradicted her client's version of events. Where basically the audio recording is her client like running after my client and him saying, "Get away from me," and he's like going outside, and she keeps yelling at him. And so, of course, as we've told you before, Christina is fierce, and people are scared of her. And if you, a couple weeks ago, we told you a story about how she just showed up in court, and the plaintiff just said, "I give up, I'm dismissing."
All right, come on now.
But anyway, but of course, she looked at me. She looked at me with no sense of irony, and just looked at me and goes, "I don't care. We're gonna have a hearing then." You have a hearing?
That
We'll have
sounds
a
like
hearing.
something I would say.
We'll see what the judge has to say about that recording.
You think you're so smart, John Knocklinger? You don't scare me. Did I say that?
Something like that. But we negotiated civil restraints, which we're going to talk about in a minute. But yeah, I just thought it was interesting because you don't know. The one thing you never know is there a recording? Is there a video
That's
recording?
true. By the way, I just want everyone to know I never actually heard that recording that he alleges was made and says these things. Do you still have it?
I still have it.
We'll have to listen to it
We'll
one
have to
day.
finish the bottle of wine later.
I have
Listen to
another
it.
great example. I represented a guy, he was a defendant, and he swore up and down that it was preposterous, these allegations that the wife was making. One of them was terroristic threats, that he had threatened to kill her. He swore there was no such conversation that ever took place. We get to court. His attorney, thankfully, showed us this, we listened to a recording, not during the trial, but before it was going to start, where he, plain as day, was cursing and said he was going to bury her, that he was going to kill her, and he was going to bury her. So, things like that happen all the time. So please, that guy should have told us that he said those things, because we were just kind of caught, as I like to say, with our pants down.
Absolutely.
I don't like that. It's not a good
Well, I'll
feeling.
tell you, every single male client that I have who's still in the house at the beginning of a divorce, I tell them to record every interaction they have with their spouse. I don't care whether there's a history or no history of them having disputes, because I'm scared to death of domestic violence.
That's right. And we've had plenty of occasions where our clients were saved because they had recorded a conversation that they had with their spouse that completely contradicted the other one's version of the story.
Absolutely. So some other surprises. We've already discussed the fact that someone might show up with an attorney, but you can deal with that by asking for an adjournment. The other surprise that I think happens much more frequently is that during testimony, the plaintiff will testify to something that is nowhere in their complaint.
That's true. That happens very often.
And the interesting part about this is that according to the law, the plaintiff is free to testify as to whatever they want, and the judge is supposed to freely allow them to do so. However, the defendant is supposed to be given due process, which means you're supposed to be given an opportunity to prepare your defense. So sometimes this might mean you go out in the hallway for an hour and you talk to your attorney, or it might mean an adjournment to a different day. So, you do have that opportunity, but don't be surprised if, and I had this case that was a little extreme, where the allegations were harassment, and while the plaintiff was testifying, she alleged that my client raped her. So, they can be a little bit more extreme. In
Yeah,
that
that's
case,
an egregious
in that case,
example.
the judge disallowed it because she said that was such a departure from what was in the complaint. But we're really talking about, if someone alleged that you texted them 5 times on Monday, 3 times on Tuesday, and 20 times on Wednesday, but then at trial you also texted them on Thursday, the judge is going to say, well, listen, it's come on.
related.
It's related.
But, sometimes they're not that egregious. I mean, sometimes it's harassment, maybe the texting, the constant texting. But, oh, by the way, they were stalking me too. He was following me, to work and to, these various places. You can't just add new facts when you show up in court.
No, absolutely. I think where people add more is the past history of domestic violence. That's where I hear most of the
Yeah, but even
additions.
that is objectionable. So
It's objectionable, but the judge will probably allow it, but they're just going to give the defendant some time in all likelihood to, because the judges don't want to, take the chance that there's an actual act of domestic violence and that they're dismissing it on some kind of technicality or because someone didn't testify as to something. So anyway, number 5 is what happens if the plaintiff loses? And this one's pretty easy and short. If the plaintiff loses, the restraining order is gone as though it never existed in the first place. There's no record of it. And the defendant, which might be your wife or your husband, gets to move right back into the house.
Yeah, it just goes away and it's instant. As soon as the judge rules and your case is concluded that day, it's done. So when you go out into the hallway, there's no restraining order.
I mean, every once in a while, I've had a couple cases where I've represented a plaintiff where the restraining order has been dismissed, and I routinely ask for a sheriff's deputy to walk my client out the car.
I don't think anyone's going to deny that, but
yeah, but that's really it.
Some people seem to be under the impression that they don't really understand that whatever provisions were in the order, they're gone. So if the order said you could have the house or said that you have primary custody of the children, those provisions are all gone.
Absolutely.
So you're just right back where you were before the restraining order was entered.
But on the other hand, number 6, what happens if the defendant loses? A lot more is going to happen.
Yeah, the consequences are certainly more.
And in fact, number 7 on our list is what remedies can the court order? So we might just discuss all of this together. But first and foremost, I think the worst parts of this are that you're going to be fingerprinted. You're going to be put in a registry of abusers. And some people in certain professions, that might impact your job.
Yes. Particularly with police officers is one great example, although there is a provision in the statute that does allow police officers to have a provisional license, or I'm not sure if that's exactly the way that it's phrased, but they're allowed to carry their gun only when they are on duty. And then they have to turn in their gun at the end of their shift. I have never personally ever seen that employed. Have you?
No.
But it is there. So a lot of times plaintiffs will feel that some pressure not to make an application for a restraining order because their husband is a police officer and they're concerned about them not losing their jobs and
because that's the money.
That's right, not being able to support the family. But there are ways around that.
Yeah, there are. There's certain other professions where I've seen it impact people. I know that some certain people that work in certain financial industries, I've heard some concern, like particularly people that work on like Wall Street and whatnot.
If you have a Series 7 license or something similar to that.
Something to keep in mind, particularly if you're not really scared of the defendant, do you want to really sacrifice your family's financial well-being because you're pissed off at them? It's something to think about.
Yeah, definitely.
So some other things real quick. You will be fined somewhere between $50 and $500. I rarely see judges issue the $500 fine. It's usually like $50 or $100.
Whatever the minimum is by statute.
But more importantly, the plaintiff, if they win, and by win I mean they get the restraining order, they're entitled to have their counsel fees paid by the defendant.
They have to ask for it,
They have to ask for it, which, how often we don't see them ask for it. You're entitled to that. That's a damage.
Yeah, that's considered compensatory damages, and you could very well be required to pay those counsel fees. I had a case one time where the boyfriend had, I think, broken into the woman's house, and she actually wanted to change all the locks, and he was ordered to pay for that, to reimburse her for that. And I think he had done some minor damage to the property. He was required to pay for that. So those are some other examples.
No, absolutely. And then, of course, it's a permanent restraining order. You're permanently, all the remedies, which we're going to discuss in a second, they're permanent. And you're going to be subject to automatic arrest, although, as Christina said earlier, that may not actually mean that you're really going to be arrested if you violate something. But you're subject to automatic arrest, which means if you
violate the restraining order.
So if you're on the plaintiff's property for whatever reason, their house was on fire and you decide you want to come.
Or you were walking by, you would live in the neighborhood and you were walking by.
And you tripped on the sidewalk and landed on their yard. I don't know. You're subject to automatic arrest. There's no questions asked. You can explain yourself when it goes before a prosecutor and before a judge later on. Not before a prosecutor, but when you're in front of a prosecutor and you go before a judge later on. But at that point, the police are supposed to arrest you. And that's why a restraining order is effective, is it's supposed to be no questions asked. You violate it, you're done. But anyway, but there's remedies. There's other remedies, and the remedies, I wrote down a list, and Christina might have some more, but exclusive possession of a house or an apartment, parenting time, risk assessments, maybe supervised parenting time. That also goes with temporary custody. I mean, a court can really order a lot of things because a lot of restraining orders aren't really with married people. It's mostly people maybe that have children in common that aren't
That's
married.
true, but even in those cases, whether they're married or not, if they have children in common, they can go on to have other proceedings in a different context to address custody, and if there's any child support issues, they can address those. But they have to be consistent with the restraining order. Have you ever had it happen where there's an order? Well, they're generally referred to as FD proceedings where the people aren't married. But if there's an FD order with certain custody provisions, and then there's a restraining order with different custody provisions. They really should be the same.
Yeah, I mean, the rule of thumb I've always heard is if it's not a divorce, if it's just a domestic violence, and there might be a non-dissolution case or a case for without marriage, that any proceeding to modify parenting time, custody, or support that's contained in a final restraining order needs to be made before, like under the restraining order docket, and heard under that docket, because you have to modify the restraining order if you're going to modify custody or anything else.
Yeah, that's a problem, and you should be mindful of that as you go forward.
Yeah, I mean, there are a couple other things. You could be required to pay support. You could be required to go to domestic violence counseling. You could be restrained from going to various locations.
My personal favorite, you can be ordered to go to anger management.
Yes, anger management. You could be restrained from communicating with both the victim and other people. There's a whole, basically the court can do anything the court wants to do if it's acting in the best interest of the victim, of the plaintiff. And if that, whatever that means, they can do it. They can restrain you from having contact with the victim's family too. I mean, they can really do a lot.
Yeah, I mean, you have to demonstrate some basis for that. But,
you do.
You know, if you've had contact with your wife or your girlfriend's family members, and you know they feel that they've been bothered by this, then the court has the authority to name them in the restraining order.
No, absolutely. So next on our list, number 8, is dismissals. And in this case, what we're talking about is there's two things. On the plaintiff's side, we're talking about voluntary dismissals. On the defendant's side, we're talking about them making an application to dismiss a final restraining order. So why don't you tell us about...
That's right. So, I mean, a dismissal just means generally that the restraining order is vacated, that it's set aside, it's canceled, however you want to phrase it. It ceases to exist. So that can happen by the plaintiff because he or she will voluntarily dismiss it. And I think it's important to bring this up because I've had many times where a plaintiff would come to me and say that I don't want to go forward with this. I got a temporary restraining order, but I changed my mind, and they don't exactly know how to handle that. They can just go to the courthouse and, you know, go to family case management or, you know, the intake and tell them that that's what they're there to accomplish. And the someone will be more than happy to put them before a judge to dismiss that. And that's whether there's just a TRO or whether there's actually a final restraining order as well. And the defendant does not have to be present for that. And if you do want to do that, the judge will ask you a series of questions. You will have to undergo some kind of counseling that day, just for the court to be assured that you understand what the consequences are, that you're no longer going to have the protections of a court order, and things of that nature. And then you go in front of the judge, and the judge will just ask you also a series of questions that you understand that you don't have a restraining order any longer. And I think they try to counsel you about the domestic violence process, the wheel of power and control.
I mean, it's the same thing that happens if you've had a final restraining order. You can go and just ask for it to be dismissed.
Yeah,
it's the same way.
It's the same process, but you can do that anytime. If you have had a restraining order for 6 months or 10 years, you can go to the courthouse and just say that you want to dismiss it, but that is permanent. So if you change your mind the next day, you know, you have very little recourse there.
Yeah, and just briefly, we're not going to go into any detail on this, but the defendant can ask for the FRO to be dismissed after it's granted, and that there's a process for that. I've never personally done one, and I've heard very little success in having them done because the judges take the approach of there was a reason for a restraining order at some point. Why am I getting rid of it? So unless the plaintiff's there like saying, I no longer want it, it's probably not going to be granted. But just understand you do have the option if you're the defendant to try to get rid of the restraining order at some point. So next on our list is number 9, civil restraints. So what is a civil restraint, Christina?
Well, civil restraints is sort of the redheaded stepchild of the restraining order. It's an alternative. So, and really, it depends on the circumstances of your case if it's appropriate for you. It sort of functions similar to a restraining order, but it's not actually a restraining order. So really
Meaning
what's
it's
different...
it's not subject to automatic arrest.
That's right. So really what's different about it is that if you violate it, it's a contempt of court, but you're not going to be arrested for it.
As Christina is blowing her nose.
This is terrible.
She's like about to die over here.
I can't wait to go home.
Well, maybe if you had a little bit more
Sick.
wine, you feel
No,
better.
the wine is not making me feel any better right now.
So what happens a lot of times is that particularly if parties are either about to get divorced or already in the middle of a divorce and there's domestic violence, we'll enter into civil restraints because the idea being that the parties are getting divorced. Most of the time, it's not really domestic violence. Most of the time, it's just someone wants to get someone out of the house or wants to get an upper hand in custody disputes. But
I'm going to live on the edge here. I'm going to take some extra Dayquil before the 6 hours has expired. You know, you're only supposed to take it every 6 hours.
are there any doctors listening to this? Let us know.
This is me living on the edge.
Please let us know how Christina's liver is doing. By emailing us at divorceduo@gmail.com. As it shuts down over here, we'll hopefully still be on the air. So,
If my liver has any damage, it's not from the Dayquil.
so civil restraints are an option where you can enter into an order providing some protection, even though you don't have a full restraining order, and it would be enforceable by the court. Now, number 10, lastly, on the list are weapons. And this is a remedy that the court will impose both at the temporary restraining order level and the final restraining order level, which is the defendant will not be allowed to have weapons and will have all weapons taken away. So what does that mean, Christina?
Yeah, I mean, this is important because I think that most people don't pay much attention to this or think that it's very important when they're dealing with all these other things. But if you're the defendant, it's very important that if you are concerned at all about retrieving any weapons that may have been confiscated, even if they're just old guns that you didn't care much about, you really need to go through that process to get them back. And more importantly, in the state of New Jersey, at least, whether you have a firearm purchaser ID card or not, it gets revoked. I know it doesn't make sense that if you didn't have one, it's already revoked. It doesn't really make sense, but that's the way that it works. So the prosecutor's office has a period of time to determine whether they're going to return these things to you. I've seen them sometimes return it, and I've seen them sometimes not. Sometimes just insist on the process. But you as the defendant, you're entitled to request a hearing and to go before a judge. And these are really kind of informal, to request that your weapons be returned, or if you didn't have any weapons that were seized, you at least should go and ask that you have the right to get a firearm purchaser ID card in the future if you want one. And I think that's really important because a lot of people just think it's not important right now, but sometimes in the future, it could be 5 weeks later or it could be 10 years later, you may decide you want to hunt or that there's some reason why you want to buy a gun and you're not going to be able to. And you're not going to be able to do this weapons hearing 10 years after the fact.
Yeah, it's an unfortunate side effect of this whole domestic violence process. Well, we hope we gave you guys some good information about restraining orders. We really skimmed the surface. We went over this very, very quickly. So if you have any questions, please do contact an attorney. We have more information on our website, centraljerseyfamilylaw.com. So you can feel free to search our articles and read a little bit more. So we're going to move on to war stories now.
Crickets?
Yeah, here come the crickets.
Crickets?
Yeah, here they come.
I find it odd that there are crickets in a war zone.
Well, it's before the
I guess,
weapons
was
started
that
being fired.
Vietnam?
I don't see. Yeah, I feel like this came from Saving Private
It wasn't
Ryan.
Iraq.
So today's war story is a case that I actually settled yesterday. And it was a case where there were allegations of alcohol abuse, and there are 2 young kids. And
What's young?
7 and 9.
Okay.
So pretty young. So this case sort of originated last summer. And what was interesting is Dad, who I represent, was alleged to have an alcohol problem. But Mom had just spent 2 years in and out of rehab facilities. Yeah. So it was kind of interesting. So she got herself clean, and now she's coming in saying, Dad's got all these problems. Well, of course, going before a judge, and again, we won't name this judge. It's not the same judge that Christina was talking about, but it's a judge that equally has some issues with decision making. Indicated that there should be no unsupervised parenting time, just based on the bald accusations of the other party. And so he had to go through an entire alcohol treatment program, and he came out of that all negative tests, flying colors. And on top of all of this, we made proposals in terms of support many months ago, along with a phase-in of our guy getting overnight parenting time over a lengthy period of time. So basically,
So it was very reasonable.
very reasonable. She said no. She wanted to fight it, and this is what happens so often. I really could tell this story in multiple ways from different clients. We go to mediation the first time a couple weeks ago, and we get really close, but she's still sort of insistent on supervised parenting time because he's still an alcoholic and the children are scared of him. So we go to mediation yesterday, and all of a sudden, guess what? Okay, I agree to everything you offered.
Yeah, like 6 months ago.
Yeah, so what happened is $20,000 each of counsel fees later.
That's
and she's
terrible.
basically just agreeing to what we proposed many months ago. And this really goes back to, and the first thing I told Christina when I called her after we settled, was just that these cases, divorces, almost always settle when someone finally gets sick of paying their attorney, or they finally get sick of coming to mediations, they get sick of the process. And it's unfortunate that people don't come to that realization earlier, but that's a lot of times when the case ends. The case ends when someone finally decides, I give up. I'm not going to do this anymore.
Yeah, I mean, I've said before many times, and I always tell my new clients this, is everybody comes along in the process in their own time. And unfortunately, the case will drag on as long as the one who's resisting. And invariably, at some point, everybody gets to a place where they just want to be done. It's exhausting. It's expensive. They just want to move on with their lives. And unfortunately, this is a great example of what happens when you've got one that sort of doesn't, get with the program as soon as they should.
No, absolutely. So just something to keep in mind. It's sort of a theme we've been doing all along. But thank everyone for watching today.
Listening.
Did I say watching?
Yes, you did.
Oh my God, that's the wine talking.
Well, you could watch soon. We are working on that. So we're not syndicated yet, though.
No, we'll be syndicated soon. But thank you for listening to the Divorce Duo on panjradio.com. Please visit our website at centraljerseyfamilylaw.com. Follow us on Facebook, Twitter, Instagram, LinkedIn, all those other lovely platforms, and email us at divorceduo@gmail.com. We will see you next week. Thanks for listening. Bye.